Ja, schönen guten Nachmittag zu der Session Die Zukunft von Whois in Zeiten der DSGVO hier beim IGF. Wir sind jetzt schon im Nachmittag angekommen. Wir haben jetzt die vorletzte Session und ich begrüße bei mir Thomas Rickert. Er ist Director Names and Numbers vom Eco-Verband der Internetwirtschaft. Und wir haben auch schon bei uns Elena Plexi da. Sie ist Senior Director bei ICANN zu den Bereichen Governance and IGO Engagement. Wir warten jetzt gerade noch kurz darauf, dass hinzugeschaltet wird die Katrin Bauer-Bulst. Sie ist Head of the Cybercrime Unit bei der Europäischen Kommission. Worum geht es heute? Das Whois-Thema ist sicherlich eines der Themen, die bei ICANN am längsten und auch schon über mehrere Jahre intensiv diskutiert werden. Und vor kurzem hatte die dazugehörige Arbeitsgruppe ihren finalen Report vorgelegt. Den möchten wir heute näher beleuchten und wir möchten gerne die vorläufigen Ergebnisse mit Ihnen diskutieren. Und dazu möchte ich gerne das Wort übergeben an Thomas Rickert, der uns einen ersten Überblick geben wird, worum es genau geht und wie wir den aktuellen Stand zurzeit bewerten können. Als eine Information für alle Teilnehmer: Diese Session wird aufgrund der Zusammenstellung der Teilnehmer, der Panelisten, die alle nicht der deutschen Sprache so sicher mächtig sind, auf Englisch fortgeführt. Thomas Rickert, ich übergebe das Wort an dich.
I'll switch to English now, so it will be my privilege to present to you the findings of the Epdp work. Can we move to the next slide, please? Now, what you see here on the slide is what you will probably have seen when you try to do a Whois lookup. And that is that on May 25th, 2018, Whois, as we knew it, went dark. So what you see primarily for several data fields is that it reads redacted for privacy. And that's for a reason. And that's because the GDPR, die Datenschutzgrundverordnung, kicked in on that very day. And ICANN had to take action on that day. Because as you know, the GDPR has massive fines, up to 20 million euros or 4% of the global annual turnover of companies available for breaches. And therefore, the ICANN board wanted to take action and ask all contracted parties, that is registries or registrars, to take action and redact certain data elements. Can we move to the next slide, please? Next slide. Can you move to the next slide, please? Sorry, I don't have control over the slides, so I have to wait for them to be brought up for you. Now, the European Data Protection Authorities, individual DPAs, as well as the Article 29 group, which is now the European Data Protection Board, have written to ICANN for the last 15 years or so, telling ICANN that the Whois system, as it is provided, is not compliant with applicable laws. Namely that Whois is far too open, that unrestricted access to personal data of those involved with the domain name registration is not appropriate and illegal. Yet, ICANN itself didn't take action. There have been a couple of community processes over the years that tried to fix the Whois issue, but that didn't really come to fruition, which is why we saw the Whois being publicly open as we knew it, meaning that registration data for the registrant, the admin C, the billing C, the tech C, including their personal addresses, email addresses, phone numbers, and fax numbers were available. And this data was harvested. It was collected by companies, by individuals. It was used for reverse lookups and all that. And that led to an awful lot of unsolicited emails sent to those individuals. And that, I think, shows clearly that there was something wrong with the way Whois data was populated and publicized under ICANN's authority. So the board took action. And let's now take a look at a couple of slides that have kindly been provided by ICANN. Unfortunately, the formatting has been broken a little bit in certain cases, so please bear with me because of that. Next slide, please. So I can't see the Okay, now you need to move backwards one slide. It reads background. So I can't see whether you're seeing the background slide. Basically, what happened subsequently is that the ICANN board issued what we call a temporary specification. Typically, policy that is binding upon registries and registrars is developed in ICANN's multi-stakeholder bottom-up policy-making process. So that means that's a global approach where everybody comes together and chimes in when it comes to developing policy. As this was a matter of urgency, that was not possible for the ICANN board. And therefore, the board issued this temporary specification that was binding for registries and registrars. But so in order to ensure that the ICANN board, which only has a few people on it, can't bypass the community process, the ICANN bylaws require that ICANN instantly starts an expedited policy development process to either confirm, reject, or amend a temporary specification. And that happened with the EPDP team. The EPDP team consists of a handful of people representing various groups inside the community. Today we have Katrin Bauer-Bulz with us. She's with the European Commission. The European Commission was part of the delegation from the Governmental Advisory Committee, for example. I happen to be the representative of the Internet Service Providers and Connectivity Providers constituency, and therefore all groups had their folks on this EPDP team and worked on a joint approach towards making Whois or RDDS, compliant with the GDPR. So we had to work on that in order to take a look at the temporary specification. We did that, but we did it in two phases. Next slide, please. So we've been working on the temp spec, but we were also asked. Temporary specification is the long word for temp spec. If you hear me using that, that's the same thing. We were also tasked to work on an SSAD, on the standardized system for access and disclosure. I will tell you a little bit more about that as we move on. But our work was split into two phases. So we delivered our phase 1 report a while back. That was a 180-page report, which I'm trying to condense into a few minutes of reporting. And then at the end of July this year, we delivered the SSAD-related report, the phase 2 report, and I'm also going to give you an overview of what we did there. Next slide, please. One slide further, phase 1 recommendations. It should read. Yeah. So this is an overview of the various recommendations that our team came up with for phase 1. And this is just for you to go through and read later so that you can inform yourself about the things that we've been working on. But I'd like to highlight a few points. If we could please move to the next slide. So when you work on GDPR compliance, what you need to make sure is that all data processing has a legitimate purpose. So we've been identifying purposes for data processing by ICANN as well as the registries and registrars. We also worked on identifying a legal basis for all this processing, because if you don't have a legal basis for the processing, you can't do the processing. We've been working on how long data can be retained, with whom data can be shared, and all that. And that resulted in us, first thing we did was we killed the admin seat, the administrative contact, because we said nobody really needs the admin seat, so we abandoned that function. So no data for the admin seat is collected today. We killed the billing seat because the billing contact has never really been used in recent history, because registrars send invoices to the account holder. They don't send it to the billing contact, and therefore that contact was eliminated as well. We're collecting less data for the tech seat, for the technical contact, and only on an optional basis, where somebody says, okay, I want my tech person to be in there so that that tech person can be asked questions immediately instead of myself. A smaller data set is permitted to travel from the registrar, who holds the customer contract, to the registry itself. So that's a change as well. Less data may be published in the public Whois. no data about the registrant is available in the public Whois except for the state, province, and the country. And in phase 2, we've also been doing some work on the city field. So the city field may be redacted. It doesn't necessarily have to be redacted by the registrar. So that's up to the discretion of the registrar. So you might see registrations where you see the city field for the registrants. For other registrars, that might not be the case. The organization field maybe will be published if that publication is acknowledged or confirmed by the registrant, but that's likely going to be phased out and only included should the registrant wish so. Next slide, please. No redacted data may be published without the prior consent of the data subject. And we hope that registrars will soon have possibilities to easily opt into the publication of registration data. And I think that function is going to be used in particular by businesses that want to give their customers the opportunity to check that the domain name is actually held by the company offering a service or providing services via a website. There is the need to provide an email address, an anonymized email address or a web form so that contact can be established with the registrant. Where a privacy or proxy provider that's affiliated with the registrar is used, that data must also be included in any Whois or RDDS query response. Registrars and registries are permitted to differentiate between natural persons, i.e. individuals, or legal persons, let's say companies, but they do not have to do so. And that was a point of major contention because a lot of folks in our team wanted the data for all legal entities to be published because legal entities' data allegedly is not personal data and therefore enjoys no protection under the GDPR. But the counter argument used by some is that company names can include personal data of, let's say, the owner of that company or the principal of that company, and therefore it can be qualified as personal data, and therefore we don't want to poison the data sets of legal entities with personal data and therefore be exposed to liability risks. Then we define criteria for dealing with disclosure requests. So what data needs to be included in a disclosure request so that a registrar can easily handle it and easily assess whether data can be shared with the requestor. And we've asked ICANN.org, we're making a distinction between ICANN, which stands for the entire community, and ICANN.org, that's Elena's employer, the entity that actually is the legal person that has all the staff and supports the community work so efficiently. ICANN.org must enter into data protection agreements with the contracted parties, with escrow agents, with dispute resolution providers, because that legal paperwork so far is not compliant with the GDPR. Okay, that's phase 1. Let's move to phase 2. That's the highlight overview of the standardized system for access and disclosure. And we're not going into glorious detail. That would be far too much for this little talk, but you should get the idea. The idea is that in these days where most of the data is redacted and can't be made publicly available, we wanted to find ways to make it easier for those who need access to that data on a regular basis, like consumer protection organizations, law enforcement authorities, but it can also be companies whose trade names are often abused and who need to check whether they can take action against infringers. So we basically built a system whereby you can, as a requestor, get accredited. So it is being checked who you are, that you actually have a legal basis for issuing certain requests that you might ask, and that is being put on file, and then you get credentials so that we don't have to check your identity each time you start a request, but we just check based on identity credentials that you are actually the person that we already know, and that's what the accreditation authority does, and that's a function that ICANN.org will perform or have performed by a contractor, and they can outsource that further to an identity provider. But the idea is that you do all the administrative work, accepting the terms and conditions, accepting the acceptable use policy, including policies whereby you might be kicked out if you try to abuse the system to obtain more data than you legally should, or if you otherwise don't play by the rules. Let's move to the next slide, please. So this is the requesting side. We have the accreditation entities. So they're asking for certain types of data. You find all that on that very slide. That's the accreditation high-level overview. I can't see that slide on my screen now. I hope that you can. But let's move to the slide afterwards, high-level overview identity providers. So they are actually responsible for verifying the identity of the requestor, after that the requestor has been accredited, and they are verifying and managing the signed assertions associated with a unique requestor. So these are data objects that you can use to basically say, okay, I'm filing my request in connection with a certain trademark, and that can be in there. Let's move to the next slide, please. So who can be accredited authorities? And I'm sure that this is something that's most interesting for Catherine, and she's been monitoring that closely. And that's for government authorities, for example, civil and criminal law enforcement authorities, data protection regulatory authorities. They can be in that game, and that would go through the national governments, i.e. their government representatives at ICANN. Let's now move to the next slide. And that contains some data on what information needs to be provided with a disclosure request. We're going to do this very quickly. The next slide speaks to priority issues. We have urgent requests where the life of individuals might be at risk. We have priority 2 level where domain name disputes are concerned, and then other requests are priority 3. That's something that was a contentious issue as well. And then next slide on recommendations 4 and 13, then the central gateway that receives a request actually channels that request either for manual processing or for automated processing. And let's move to the next slide and yet to the next slide, which would be slide 18. I hope that these slides will be made available to all of you for reading in detail. So the manual track means that the contracted party will manually review the disclosure requests and assess under their local laws whether the disclosure request can be honored, and they will then provide the information back to the requestor. The more interesting part, I guess, is on the next slide, and that is the automated processing, because the idea is that over time we will have as much automation as possible, so that no manual intervention is required. And that was difficult because that's pretty much uncharted territory. There are a lot of legal issues surrounding that. And the legal advice that our group obtained basically said that it is safe to use a limited catalog of automated cases to start with. For example, for requests from law enforcement in a local or otherwise applicable jurisdiction, which has a legal basis clarified and a few other things. Right? Also, requests for, let's say, only the city field, so that you have a first point that you can grab on when you try to assess whether it's worth pursuing a domain-related dispute. Right? Let's move to the next slide, and I will end soon. As I mentioned, the catalog of automated disclosure cases is very limited, and therefore we thought that this system needs to evolve. But at the same time, we don't want this lengthy community process to be required whenever, let's say, there's a change in legislation or we get advice from the European Data Protection Board or otherwise, that we can actually do more automation. Therefore, we've come up with the idea of a GNSO Standing Committee, which is basically a low-threshold group that can change and amend the policies for the SSAD. Next slide, please. And now comes the frustrating part, and that is that after all this work, we did not find consensus on all the recommendations in our report. So you need to move to the next slide, I guess. Next slide, please. Consensus designations, it says. And there you find the list of recommendations that enjoy full consensus. That means that there is unanimous support for the recommendation. Then we have a couple of recommendations with consensus or rough consensus, where a few didn't like the recommendations. Then we have quite a huge number of recommendations that only got strong support but significant opposition. That means that there were a substantial number of representatives or groups that did not like the recommendation. And on two recommendations, we had divergence, which means that the group does not have consensus, basically that those two recommendations failed. Last slide for me, before I yield the mic. Elena will now explain to you the next steps in the ICANN world that are required so that these policy recommendations of the Epdp team can actually become binding policy for registries and registrars. So this is not yet over. And it's also worth noting that the SSAD is just one option that we're currently building. It is still possible for requestors, be it private or public requestors, to approach a registry or registrar individually. So it's not the end of the world should this project fail at the end of the day. It's just an alternative route to provide for more standardization and easier exchange of information at the global level. I have my personal thoughts on all this, and I will chime in later during the discussion when I have my few minutes to share my opinion. Back over to you. I don't hand over back to Lars. I'm handing over directly to Elena to talk a little bit about the next procedural steps. Over to you, Elena.
Thank you so much, Thomas. I hope you can hear me well. I feel like apologizing at the offset for not being able to speak and understand German. Had it not been for me, I guess we would have had the session in German altogether. So Thomas gave us a very comprehensive description of the whole work of the Epdp. It's amazing in how he managed to do that in a few minutes. I will now only refer to what comes next. In the ICANN world, there are two important steps that comes next. One is the generic name supporting organization, the council of the GNSO actually, that has to review the Epdp recommendations for approval. And then the ICANN board of directors, which on condition that the GNSO council has approved, will have to adopt the recommendations. In a little bit more of detail, the Epdp submitted the final report to the GNSO Council on 31st of July. Then the Epdp team groups had until 24 of August to submit minority statements for inclusion to the final report. It has to be noted that 8 out of the 9 groups that work in the Epdp submitted minority statements. Now, the GNSO Council will begin discussion of the Epdp Phase 2 final report during its September 24 meeting. The GNSO Council may vote on the report during this meeting or may defer the vote to the October meeting. As far as we know, the GNSO Council will likely vote on all the SSAD-related recommendations as a package. It has to be noted that given all the minority statements, the GNSO will not have an easy task ahead of them. And we have already seen Phase 1 when the GNSO Council had to vote for the Phase 1 Epdp recommendations. The recommendations were approved by the GNSO Council, but for the IPC-BC, which at the time did not support. Again, if the GNSO Council votes to approve the Epdp team Phase 2 final report, then the report will be submitted to the ICANN board for its consideration. And the board will consider the recommendations for adoption in approximately December 2020. Now, the ICANN board has a fiduciary duty when considering, which means they will have to exercise this duty. This duty includes, for example, considering the expenditure involved in such a project. And I stop here with the next steps. Back to you, Lars. Thank you.
Thank you very much, Elena, for giving us an overview about the next steps and the potential next steps. So now we would like to take a closer look at the Epdp recommendations itself. And so I would like to hand over to Katrin, who will give us a brief overview of the reactions from the government side that she's representing here on this panel. So Katrin, the floor is yours. Thank you.
Thank you very much, Lars, and I hope I can keep your attention also in terms of keeping the connection. So, as Elena noted, the GAC was one of the 8 out of the 9 groups that submitted a minority statement on this very important process. And as you may know, the GAC represents the governments in the multi-stakeholder context of ICANN. I myself work for the European Commission, which is a member of the GAC, so I'm not in any way an official representative of the GAC or of ICANN. But as the European Commission, we have very actively contributed to this process, both by fielding a representative via the GAC to the EPDP, and also by trying to shed some more light on the EU legal framework and most notably the GDPR, while of course staying conscious of the fact that the ultimate arbiter of how the GDPR is to be implemented is not the European Commission, but rather the national data protection authorities that come together in the European Data Protection Board and the national and EU courts. Now, I want to start out by acknowledging the immense amount of effort that has gone into this process. I think Thomas's presentation conveyed this quite eloquently. It was an extremely intense work, and all of us would have hoped that there was more universal endorsement of the recommendations as they have come out. We still think as the GAC that there were a lot of points where everybody agreed. So I think while I will go now into a number of points where the GAC has disagreements with the recommendations, it is fair to say that especially when it comes to the overall accreditation model and to the submission of requests for treatment, the GAC very much welcomed the work, and the standards that were set for requestors have been almost universally welcomed. So there are a number of aspects where the EPDP recommendations were also by the GAC wholeheartedly endorsed. However, just allow me to remind you that for governments, this is a very special setting. We're dealing with the internet, and domain name registrations are the basis for websites that can be accessed by anyone from anywhere. And that's the whole purpose of the domain name system. It creates lots of opportunities for the exercise of fundamental rights like freedom of access to information or of opinion, but it also creates a number of risks in a nutshell. And you find this balance, and here I come a bit to the specific German context, you find this balance reflected quite well in German law, specifically, for example, in the requirements stemming from the e-commerce framework that anyone offering services online is required to list a contact on their site. Or German law goes even farther and says that anyone who publishes anything on the internet has to include the so-called impressum, has to include a portion of the site identifying him or herself or identifying someone who takes responsibility for the content that is made available. Now, the legitimacy of these laws has, of course, not been called into question by to my awareness by any data protection authority. Now, such an obligation does not exist in many other jurisdictions, and that's why the Whois was so important, because it allowed us to create that same minimum level of accountability on a more worldwide level. Of course, it was not always accurate, but we'll go to that later. So just to be clear, achieving this objective of a limited degree of accountability would not necessarily require pervasive public availability of personal data, but it would require a solid and reliable system for granting access to that data for legitimate purposes, and that's something that the European Data Protection Board has also explicitly referenced. Now, as I said, the final recommendations contain a number of useful elements, but now I will go into the GAC minority statement and just briefly outline 7 points where the GAC took issue with the recommendations. First of all, the recommendations set out a fragmented rather than a centralized disclosure system. The downsides of a fragmented system are that disclosure decisions are entirely up to each of the more than 2,000 registrars around the globe, who each have to come to their own interpretation of what the relevant legal bases of the GDPR mean to them. And that creates a serious issue when it comes to even application of the rules. So this is something that the GAC has not welcomed. As a second point, and immediately related to that, there are no enforceable standards contained in the recommendations that would allow any sort of overall horizontal review of disclosure decisions. And that prevents us from setting any kind of general standard or reviewing the appropriateness of either a disclosure of data or of a refusal to disclose. Thirdly, the GAC found that the recommendations do not sufficiently address consumer protection issues. Those are requests related to consumer protection are assigned the lowest priority level in the overall request system, and that's not in line with what would be required for effective consumer protection. As a fourth point of contention, the GAC does not consider that there are reliable mechanisms to allow for an evolution of the system for standardized access and disclosure. While Thomas said that there is a GNSO standing committee, the recommendations do not contain any particular processes or points that would enable a sort of structured approach to these updates. As a fifth point, the standardized model may impose financial conditions that risk disproportionate costs for its users, namely for the requestors, including those that detect and act on cybersecurity threats, who often need to follow a number of websites because, as you may be familiar, or rather a number of domain names, as you may be familiar with instruments such as domain generating algorithms, which will automatically register for you hundreds of sites with the names of which are automatically generated by the registrar's tool. The security authorities trying to identify where a cybersecurity threat is coming from would potentially need to verify a number of these sites and a number of the Whois information of these sites, and that could become very costly very quickly. As a sixth point, the final report does not address certain key issues, most notably on data accuracy, on the masking of data from legal entities, and the use of anonymized emails. So just on data accuracy, there is an interpretation that holds that data accuracy is simply a right of the data subjects. In the view of the European Commission, this is not correct. And again, it's for the DPAs and the courts to give the final interpretation on this, but the European Commission holds that data quality is also something that the data controllers need to ensure. So in this case, those who set the rules for how Whois data is processed. And inaccurate data does not serve any purpose, which is why data quality also contains a requirement to ensure accuracy of data within reasonable limits, of course. And then finally, one thing that the GAC identified as a missed opportunity is that the model does not clarify the status and role of each of the data controllers and processors, which is really a fundamental thing under the GDPR to create clarity about who is setting the rules and who is implementing the rules so that the data subjects know who they are dealing with. And that is one area where GAC saw a missed opportunity. Now, those are the 7 points I want to highlight from the statement. Let me just close by saying that the GAC's refusal to sign these recommendations has been mischaracterized as a refusal to do anything on these issues. That is not the point. The GAC, as the government's representative, has the responsibility not to be seen as endorsing something that it thinks is the wrong starting point. And that's why the GAC was not able to endorse these recommendations and thinks that it's necessary to go back and review these points in more detail. Thomas said that the goal of the exercise was to make it easier for entities pursuing legitimate purposes to obtain access to the Whois data. And the GAC fully agrees. The recommendations in their current form are not yet there, and I'm afraid we will need to take another closer look. Thank you.
Thank you, Catherine, for providing us more insights on the view from the GAC side on the current status of the Epdp recommendations. So I would like to give the floor back to Elena to give us the perspective from ICANN org side. And for those who already put in questions into the question and answer tools, we will come to that part after the part from Elena about the perspective from ICANN org side. Thank you very much.
Thank you, Lars. Thank you very much. So now that it's my turn to express perspectives, I can officially, let's put it that way, invite you thank you for inviting me. I'm happy to be on this panel with Thomas and Catherine and discuss this issue. Well, first, it is very important to note the many hours of hard work done by the Epdp members to come up with 22 recommendations. there was a huge amount of effort and investment by the Epdp team members. I personally admire the efforts they put in there. One of those members that puts that many hours is Thomas. And I admire him and the rest of the members for their commitment and determination. Was not an easy task. And it is also important to note that the Epdp designed the system based on their and our best understanding of what is possible under the law. The system, the model that the Epdp put together is, to our view, the best possible outcome we could have given the uncertainties and unknowns that are there when it comes to implementing the law. One thing to remember is that this particular policy development process is different with respect to any other within ICANN, in that the community was working to implement the law. And we have to be clear here with respect to where is the border as to what the multi-stakeholder community can do. The ICANN community is there to set policies on the DNS. It is not there to interpret international law. And in this particular case, the Epdp had to come up with consensus policy to implement a law that is complex, and that is for good reasons. It is flexible, and that is to accommodate for different situations, different industries, different needs, always with the key aim to protect the data subject, of course. And flexibility in this context, in this law is not a problem, it's not a bug, it is, if I may call it that way, it is a feature. And hence it is no accident that the legislators has tasked the data protection authorities with interpretation of the law, with issuing guidelines to guide controllers and processors through the open issues and questions that are there. And there are a number of them. The Epdp, to my mind, came across some of the most important ones, and that played a role to what they could decide, to what they could put together as a system. As an example, and Catherine mentioned that before, the accuracy question, which the Epdp did not tackle. As Catherine, of course, correctly mentioned before, there are legal memos or interpretations or people's understanding that accuracy is a right for the data subject and not an obligation for the controller. And hence, the GNSO did not task the Epdp to tackle this. But then, as we heard from Catherine, and also we read in the GAG minority statement, it is not just the right. Another interpretation, if you will, is that it's not just a right, but it's also an obligation. Quality of data is also an obligation. If this is the case, then it makes a difference. Another example is the international data transfers. On this, the European Commission has said in its report on the 2 years application of the GDPR that they will provide standard contractual clauses, and this guidance will be very, very helpful going forward. Another point is the uncertainty on how to apply the so-called balancing test, which is the big problem for the contracted parties. Because here, to be honest, what is being asked of the contracted parties is difficult, is a burden. They have to uphold the public interest served by access to Whois information, while at the same time risking scary sets of fines. What would anyone do if we were in their shoes? I guess any sane lawyer would advise them, while performing the balancing test, to stick to rather evaluating privacy rights in absolute terms to avoid possible fines. So upholding the public interest should not be on the shoulders of commercial entities such as the contracted parties, but it should rather be on ICANN org. And here I'm talking about the responsibility for disclosure, which is the one generating all the risk. And that is why ICANN org tried, and also in response to various calls that we received from a lot of stakeholders, including the governments, we tried to test a unified access model with the data protection authorities. Generally, throughout this process, and to help inform the Epdp work by gaining greater clarity about how the law applies, we engaged with the European authorities as much as we could. And here the contribution of the European Commission has been very, very important and very helpful. So this engagement included sharing with the European Data Protection Board a possible unified access model that would be a centralized model in both the request side and the response side, where the responsibility for disclosure, and I repeat for disclosure, would be placed on a central gateway as opposed to individual registries and registrars. We're talking about the decision on whether to disclose or not and the actual disclosure. The key question that we wanted to clarify with this paper, with this model that we hypothesized, was the controllership issue when it comes to the processing activity of disclosure. And in a discussion that we had with the Belgian DPA in February 2020, the authorities' representatives noted that such a model is worth exploring, and also that it seemed to be a better common sense approach in terms of security and for the data subjects. And here I'm quoting the Belgian representatives. But the thing is that to date, we have not received a definitive answer on controllership by the authorities. So that means that the community, while working, they could not base themselves on something concrete, or they didn't have something that they could act on. To sum it up, let me repeat that to our view, this is the best possible outcome we have, given what we know. The community worked together to devise a proposal for a hybrid model that allows for standardized disclosure requests. So it's actually the request side that is standardized. This is the basis for any solution, be it we stick to this one or perhaps, if possible, evolve in the future towards more standardization, or as Thomas was explaining before, towards more automation, also with respect to the response side. And I think we should not underestimate this outcome. We hear assertions by some that the Epdp and the ICANN multi-stakeholder model has failed. I respectfully do not agree to that. I think that the fact that we have this outcome shows that the model is working, with, of course, all the problems it has, because it's not a perfect model. But there is a limit, as I said before, to what the model can do, and that limit is, in this case, the law. Now, one can ask the question, does the situation beg for legislation? I will refer again to the public interest example. The GDPR, as we said before, being a flexible law, foresees the public interest as a purpose for processing. Nevertheless, all of us that are discussing this issue, we might admit to each other that there is a public interest aspect into legitimate access to Whois information. But just the fact that we are discussing it and agreeing amongst ourselves does not suffice. Public interest has to be defined and laid down in EU law. Aside legislation, guidance. There is no question as to the need for more guidance as we go forward if we'd like the model to possibly evolve. I'll leave you with those thoughts and just say that on our side right now we're looking forward to the GNSO Council discussions and to hearing more from their deliberations. Thank you so much.
Thank you very much, Elena. Thank you for presenting the ICANN Org's view on the report. So I would like to hand over now back to Thomas. And I would like to give one of the questions from the chat also to him, which is on Thomas Ricketts' first presentation. What's the average duration of any such data redaction proceeding?
Very much, Lars. And to answer the question, at the moment we don't have an average response time because the system is not yet operational. But the duration will likely span from I think a working day to 3 working days or something in that range once it's operational. But rest assured that at the moment, from my experience, registrars often respond in a matter of hours if there's something urgent coming up. Now, there's so much to comment, and we have so little time left. Let me start by saying that I was a fan of the open Whois. I did love it. I'm a lawyer by profession, so I've been working on tons of domain name disputes over the years, and certainly it was great to be able to just look up all the information, do reverse lookups and all the like. But these days are over, and I think we have to accept for a fact that we can't try to maintain something that has been blatantly illegal for many years. But we have to adapt our expectations to the new legal reality. And I think that includes a couple of points that have been mentioned earlier. Yes, it would be great to have the information easily available. Yes, it would be probably desirable to have it all accurate, but the Whois database was never meant to be an authoritative database for law enforcement to base their investigations on. It was a database basically for technical context if something's wrong with the resolution of your domain name. And it has been tried to be repurposed over the years. But other than, let's say, trademark databases or the imprint requirement that we see in certain jurisdictions, there are laws based on which this processing is permitted. And we don't have such law for a Whois database, at least not for generic TLDs. There's something like that for some CCTLDs, but that's the reality, the legal reality that we have to live in. I'd like to focus on two aspects, I guess, that I find really striking in this outcome of our 2-year work, hard work, I should say. We've spent so much time on this, and that is my disappointment that it's primarily the requestor side of the community, those who represent those who will likely file disclosure requests, that have now not supported key recommendations. That's the intellectual property constituency, the business constituency, the governmental advisory group, and the ALAC, the user representation, as they call themselves. And therefore, that begs the question, if we only have paper-thin support or even no support for certain recommendations, for example, on financial stability or sustainability and on the evolution model, we have divergence. So basically that is a recommendation that has failed. How can we build and further continue to consider a model that is obviously not wanted by the requesting side? And can we really ask the GNSO Council and the ICANN board to greenlight massive expenditures on top of the massive expenditures that have to be spent by registries and registrars to implement all that, if the value is deemed to be very limited by those for whom we have built all this? So I think that's something worthwhile considering. I think also not honoring the outcome of a multi-stakeholder process where everybody was working on coming to consensus with, I guess, the best intentions, and then not accept that, but still opposed to key recommendations. I think that erodes and undermines the multi-stakeholder model and fuels those who are asking for more regulation in this space, which I think is counterproductive. So having said that, I think we need to ask ourselves, where do we want to go with this? And also, why are we where we are at the moment? And I think that part of the reason why we didn't get any further is that the requesting side was asking for the new Whois type regime to resemble as much as possible the old regime, and for the data to be as accessible and easily accessible as possible. And that's just legal la-la land. You can't have that, right? And that certainly made the registries and registrars more cautious and being willing to be more courageous with their disclosures, because it's ICANN, the registries and registrars, that have the legal risk if they disclose data that shouldn't be disclosed. And we're actually concerned about protecting the data subject whose data is in that database. And that's sometimes sensitive information about political speech. Let's remember that's at the global level. People might get arrested tomorrow if the data is easily revealed. So I think that's something that we should consider. I think that that those who've been asking for more disclosures should realize that maybe part of the reaction by the contracted parties to be more conservative has been triggered by their partial overreach in being more flexible with data disclosures. So I think I would like to leave it there and hand it back over to Lars for maybe one or two more questions and final and closing remarks. Thank you.
Thank you, Thomas. Katrin just raised her hand and would like to respond to your statement. Katrin, the floor is yours. Katrin, if you're speaking, you're probably still on mute. Katrin, we can't hear you. Okay, we seem to have lost your audio connection. Can we ask the technical team? She's got the impression that she can't unmute herself. Okay, thank you. So, if we can't get an audio connection back to Katrin, I'm very sorry about that. It wasn't the intention to block any responses to what Thomas just said. We still have one open question in the chat, which is if the domain holder is held responsible for website content in the context that we are currently discussing. Thomas, would you like to take that on?
So the question is whether the website owner or the domain holder?
If the domain holder is responsible for the website content.
Well, that's a legal question. It pretty much depends on who is responsible for the content. So the content provider would be the primary responsible party for that. Sometimes this is not. Sometimes the content provider is not the domain owner. So it doesn't necessarily have to be the domain owner, but if the domain owner is actually authorizing that certain content is publicized under his or her domain name, then that can be attributed from a liability point of view to them as well. So it depends, and this is, I guess, it's an excellent question, because I think it should remind us that the entity responsible for the content might not always be the domain holder, and therefore, publicizing the registration data for all domain names or making that easily accessible might lead to the false impression that it's always the domain owner whom you can go after. I mean, look at social media platforms, look at hosting providers where content is made available under a directory or a subdomain, where multiple users or customers are using the same domain name. We don't want the poor domain holder to be fully responsible for each and everything that's been publicized and offered thereunder.
Thank you, Thomas. So if we don't get a proper connection back to Katrin, I would like to close the session right now here. What we can say now, yes, we do have a final report on the Epdp working group, but what is clearly now after the session is that we still don't have a final decision on the future of Whois right now. So this discussion will continue, and of course, we will still be engaged in that process, and we will keep you informed about this process. So I would like to close the session right now. Thank you for your attendance, and I wish you all the best for the rest of the day, and also with a final session of the IGF Germany, which is taking place in a couple of minutes in the next room. Thank you very much.